Good morning or afternoon. I'm Megan Kelly. I'm the Director of Attorney Development here at Paragon. For those of you who are not familiar with Paragon Legal, we partner with in-house legal departments to provide flexible interim attorney support. In that same vein, we offer attorneys a way to practice law on more flexible terms. Whether you need coverage for an attorney colleague's leave or your legal department's budget is impacting your ability to hire, Paragon Legal is here to leverage its expertise and will collaborate with you to get you the support you need from experienced legal counsel on our team. And joining me today is Jenny Sheridan. Jenny started as a corporate attorney, and she has worked in-house for several Silicon Valley tech companies, including serving as general counsel for privately held and publicly traded software companies. She founded JLSheridan Law, a boutique law firm focused on tech transactions, privacy compliance, and IP counseling in 2014. She also teaches as an adjunct professor at Santa Clara University School of Law and Mills College School of Business. She is an IAPP privacy professional with CIPP US and E certifications, and we are absolutely thrilled to have Jenny with us today. Welcome, Jenny.
Thank you.
A few housekeeping items before we get started. This session will be just about an hour, and we're going to aim to reserve some time for questions and answers at the end. We ask that you please submit your questions through the question dialog box in the GoToWebinar interface. Please also use the chat if you encounter any technical issues. And you can email Kristen Poor at paragonlegal.com. She'll drop that email in the chat as well with any technical issues. We ask that you remain muted throughout the conversation. This will be recorded, and we'll share it after the fact along with the related materials. And anyone who's looking for CLE credit, you will be emailed a form following the session as well. And now with that, we'll get started with today's session. Before we dive into the substance, Jenny, it may be helpful to set the stage with a brief overview of the topics you'll cover today.
Thank you, Megan. It's a pleasure to be here. Really honored to be invited. So what I'd like to focus the talk on today is the perspective of the U.S. practitioner based in California, like I am. And I don't know if all of you are in that situation, but I'm going to start with that. And we're going to look a little broader. But I want to focus on what do we have to worry about here in California, the privacy landscape. You know, what has changed in 2023? It's really an inflection point in privacy compliance, especially for the United States. And back in 2018 was when we had the first consumer privacy law was passed, CPPA. And that came into effect in 2020. So that's when I started doing California or any US-based consumer privacy law compliance for my clients. But what has happened very rapidly is, first of all, that law was amended pretty significantly by a proposition in California, Proposition 24, CPRA, modifies CPPA. So it's still, the law is still, sometimes it's confusing, but it's still called CPPA. But as of January 1st, 2023, it was modified. The other thing that's happened is we have 4 other US states that have kind of followed California's lead with passing privacy law as well. Virginia, their law went into effect in January. In July, we have Colorado and Connecticut. And in December, we have Utah. And some of the high-level topics that we're going to talk about that relate to these changes are some new categories of personal information. We have something now called sensitive personal information that we're going to talk about. We have a new requirement called impact assessments for high-risk data processing. And then we also are going to start to have regulation of something called automated decision making. So we're going to talk about those topics. What we're not going to cover is the recent Attorney General regulatory action, namely against Sephora, and in more broadly ad tech compliance, which is a really highly specialized topic. So we won't cover that here, but I'm looking forward to discussing these topics.
And so are we, Jenny. To kick it off then and get into the content, we can start with a short overview of the privacy landscape coming into 2023.
So one of the themes that I think is really important and I want to emphasize in my talk here today is GDPR is coming to the US. So some of you might be familiar, like my daughter, who is a big Game of Thrones fan, the cultural meme, winter is coming. So I kind of chuckle when I kind of thought of this, GDPR is coming. Now, again, it doesn't mean that it has to be scary, but we have to take note. And I think that even if you're focused on a US practice, it's going to be more comfortable for you if you get familiar with GDPR. So that's why I want to spend just a couple minutes explaining why. So when I started doing the California privacy compliance, I would explain to my clients that there's covered business, and we talk about who is a covered business. That's the entity that's collecting and processing the personal information. Then we talk about service providers. Those are the entities that the business is sharing the personal information with in order to provide its business to its customers. We would talk about personal information. We talk about a consumer. Well, I was already practicing GDPR for my tech clients that had EU customers. There, the terminology, and some of you, or many of you probably have heard this, data controller, data processor. In the GDPR lexicon, data controller is the entity that, in the way GDPR defines it, determines the means and purposes of processing the personal data. They also use personal data rather than personal information. The data processor is the entity that is going to process that personal information on behalf of the data controller. What is very interesting with these 4 new US laws is they're not following California there as far as terminology. They're following GDPR. They're using that same terminology. So what I'm interested to watch, and also, well, let me add 2 principles of privacy that we've seen in GDPR. Purpose limitation, data minimization. We, up till now, up till 2023, I could advise my clients to be pretty broad about the data that they collected. Starting in California in 2020, we had certain notices we had to give. We had to do some analysis about whether we were considering sale of personal information under California law, but we could collect any information. There was not restrictions on that. In the EU, they have first of all had these principles that you need to disclose your purpose for collecting, and then you need to collect only the information that's reasonably necessary and proportionate to meet that purpose. That has now come to the US. Now, what hasn't come to the US is there's even more restrictions in the EU. A data controller cannot even collect information unless they have a lawful basis. And those of you that are familiar with that, you'll know there's things like performance of a contract, consent, there's a few other, but that's very restrictive. Now, I don't see that yet here in the US, but we do see these principles. And I think what's going to be interesting to watch is the interpretation by the regulators. Are they looking to the EU as far as taking cues about interpretation? So it's too early to see. And then one other thing I'll just add before I hand it back to Megan is the other thing we're seeing that's influenced from the EU is opt-in consent. Now, not California, interestingly, we'll talk about this in more detail with sensitive information, but California is doing an opt-out. But the other states, well, 3 of them, Virginia, Colorado, and Connecticut, doing an opt-in, and they're defining opt-in the same way as GDPR. Freely given means it's revocable, informed, specific. So it's a new world that we're seeing, I think, in 2023 with this GDPR influence.
Wow. Jenny, I know when we were connecting in preparation for this, you mentioned you, like me, benefit from practical examples when learning about new topics. And so you proposed viewing today's session from the perspective of a B2B business-to-business software company. Do you want to fill us in on the use case here?
Yeah, absolutely. So that's, again, like how I got into data compliance was because of my B2B tech companies. And it, again, really started in 2018 and then just expanded in 2020. But the hypothetical we're going to use for this discussion is an ABC Corp. So ABC Corp is a SaaS company. It's got a SaaS solution. I'm sure many of you are familiar with that. Typically, there's a subscription model, so we can assume they have a platform that's hosted, like on Amazon Web Services. Their customers are enterprise. They're not individuals. They're businesses that, think Workday, Salesforce, all of these different platforms. And then their customers, the personal information that's coming onto the platform is their customers' employees or customers. So we're going to assume that ABC did the work to do a CCPA compliant policy in 2020, but now they're looking at what do they have to do with CPRA? What do they have to think about with these other US laws? So Megan, if you could pull up the graphic, we're just going to show that because the key beginning point for privacy compliance is what we call data mapping. And I do a high level data map so that I have a good idea of, again, the sensitivity of information that's being collected and who the parties are. That's what's really important as far as being able to draft compliant documents and counsel. Counseling is a big part of it too with the different requirements. So here, as we see in the center of the graphic, is our client, ABC, SaaS company. So on the right-hand side, enterprise customers, we just numbering them 1, 2, 3. Those are the customers that are going to, they're in GDPR world, we call them data controllers. Okay, we're calling them the business under CCPA. They're the ones that are providing personal information to ABC. Now, if you see the legend on the bottom there, I list what are the types of personal data. I use personal data here. Name, email, IP address. So what I do when I start with a client, I have like a 2-page questionnaire that I have them complete, and then I discuss it with them so that I can understand again and fill this out for myself. What types of personal data and what are the flows? So there's a data flow first from the enterprise customer to ABC, and then there's another data flow out from ABC to these third parties that, as I was saying, under CCPA, we call service provider. Under GDPR, we call a sub-processor. And I have another legend there on the bottom left that kind of converts for you to show you this, which again, as a US practitioner, you're going to have to get familiar with this now because the other state laws are using that terminology.
Great. Okay. I'm going to pull the graphic from the screen now, but it will be available in the materials. Jenny, you mentioned ABC Corp has a CCPA compliant privacy policy in place, and we are going to look at what ABC Corp needs to do to be compliant with CPRA and other state privacy laws in 2023. So what are the new consumer rights under the CPRA?
So one of the big changes for B2B companies like ABC in 2023 is the basically expiration of this moratorium that existed with the initial CCPA. So the initial law had a moratorium where there were some exemptions for B2B data and employee data. So think about that graphic where I talked about the customer for ABC. Let's say John Smith is a CFO for XYZ company that's their customer. Under GDPR, John Smith, that personal information is covered and you have to follow the certain rights and notices, et cetera. You didn't have to do that under CCPA, that was exempted. Also employee data. Whereas again, in GDPR, employee data is covered. Nonprofits are covered in GDPR, very expansive, but CCPA was narrow. So for ABC, we still had to do an analysis of whether or not we sold that information of like John Smith. Okay, then we would have to give them the right to opt out. So what I did in 2020 with my clients is we did an analysis for the B2B. If they were selling the personal information, my ABC client was not. So we would still, on the privacy policy, state that they're not selling personal information as defined under CCPA. And there's something about rights of discrimination. We'd also note that we're not discriminating, again, based on their rights. But what's happened now is basically John Smith's information is, you have to give them the same rights like you would a consumer. So I also have B2C clients, say like have an e-commerce engine on Shopify. So when I do compliance for them, I have something called a California users page that I do a layered approach, because that's what's been recommended by the FTC is, again, not have a 20-page privacy policy. It's better to have a shorter main policy and then hyperlink to certain things, like explain your cookies, explain things like your specific California users notifications. So what I was doing for the B2C, I'm now doing for the B2B, is those California users' rights. So like the John Smith could get a right of access and ask ABC, what information do you have about me? Will you delete it? The same kind of rights that you have under CCPA. What also has been a task, some work for my clients, is on the employee side. So now, even under CCPA, I don't think there's probably a lot of companies weren't doing this, but you still were required to give some notice to your employees under the first round of CCPA. You were supposed to notify them of the type of personal data or personal information you were collecting and what was the purpose. Now, though, it's ratcheted up to just like consumers. Now you have, in California, you have to give your employees not only a notice, but you have to give them the same opportunities for right of access, right to correct, right to delete. Now, the way we're doing that operationally is we're not putting that on the public website like we are for our consumer policy, but it's typically your employee manual needs to be updated. You need to send an email to all your employees. This also is contractors and job applicants too. So again, if you're really getting fully compliant, this is a big requirement, okay, for companies. And I have a lot of privately held clients, so it may not even have a full HR department. So it's a certain amount of work. Then the other more update to the privacy policy now is under California, we have the right to correct information. You had that in the EU. We didn't have it in California. We have that now. The other two categories are bigger. There's a right to limit the use and disclosure of sensitive personal information. So we're going to dive more into that in a minute. And then the other right now is to access information about automated decision-making and the right to opt out of automated decision-making. And again, we're going to talk more detail about that. But that's why that data mapping is really important, because that kind of gives you an idea as counsel, hey, am I in these territories that we're going to have to spend more time with the client if we're in like sensitive information, automated decision-making.
Yeah. Okay, Jenny, one of the items you mentioned was this right to limit use and disclosure of sensitive personal information, sensitive PI or SPI. Can you tell us a little bit more about what SPI is or isn't?
Yeah. So, I think as Megan has said, there are some materials. So you'll be able to see, I have a slide that has a list of that for California. So you'll be able to reference that. And what I did on that slide too is I bolded those types of sensitive personal information that we don't see in the other states. So this is one of the interesting things now. Again, you've got to like compare the different states. But what I like to start with, again, the influence of GDPR. In GDPR Article 9, we have something called the special categories of personal data. And so some of these categories of information that are in the California law now, like racial, ethnic origin, religious, philosophical affiliation, union membership, genetic data, biometric data, we see those in the Article 9 special categories that in the GDPR, you have to have explicit consent. So it's a really high level of opt-in consent to be able to process that information. Oh, sorry, the other thing, the Article 9.2, the health data, sex life, sex orientation, that's also in the California law. Now, what's interesting in California is we have 3 other areas that are special to California. We don't even see those in the other states like Virginia, Connecticut, Colorado. In California, we have government ID, so social security card, driver's license, passport. So that gets really interesting when you do the employee disclosure, because of course, for I-9, other reasons you have to collect that information. Another particular one for California is consumer login with a financial account and security or access code that will allow access. That has to be treated as sensitive information and notified users. And then the other unusual California one that causes confusion to a lot of people is consumers email a content unless business intended recipient. So there hasn't been a lot written about that. And I have to say in my practice, it doesn't come up because like my ABC client, the communication that's happening between them and their customers is all business related. So it sounds to me, again, like I haven't studied this, but like Google, right? If you are hosting emails and there's lots of content going on in there, okay, you could be in for California sensitive information, but that's unique for California, those other categories.
Great. And with respect to this SPI, what are the updated obligations under the CPRA?
So very interesting. So remember, like California, we were first out of the gate with our first law, and then Alistair McTaggart, he was the fellow who's been really active in this area. That really, the reason that there was the first CCPA was because he was going to do a ballot initiative for that. But then the legislature decided to adopt a bill very similar to his initial initiative. But then he decided it wasn't rigorous enough. And so that's why in 2020 proposed Proposition 24. So one of the places that it's, again, we've diverged from the other US states is in this area of sensitive information. It's an opt-out right. So if you think about it, what happens here is if the covered business is collecting information that's considered sensitive, they have to, again, in their notifications, they have to show that privacy policy has to include, we collect these different categories of sensitive information, but they can wait until the consumer contacts them and says, hey, why are you using my information? Now, the other important thing for California too is we have some exceptions. So let's say you're a company that's doing genetic testing and the consumer knows I'm providing you some important information for you to give me those services. That's exempted. So California is really concerned about broader use of the sensitive information. But what's going to be different with the other states is they have opt-in. So there, if you think about it, they're going to be violating the law if they are processing that sensitive information without first having the consent, which is the way the GDPR regime works. So I haven't studied those statutes to know what kinds of exceptions they're going to be. I would imagine they are going to also have exceptions too. But if you think about it, this is my other theme for the talk, is harmonization. If you represent business, you know that we don't like to have several, even if it is full employment for privacy professionals, it's a real headache for business. So I kind of compare it, and I'm not the only one that's made this comparison, to the 60s and 70s with the California laws about environmental restrictions, pollution that affected car manufacturers. Detroit wasn't going to make one car for California and then a different one for other states. So that's what I'm also watching, is how is the harmonization going to work? So I would imagine that in this area of sensitive information, we're probably going to move towards some kind of opt-in consent regime. With California, like I said, there's exceptions, so it depends on what the activity is. But harmonization, that's another theme that I think is really important to look at.
I understand there's a new requirement that we haven't had before in US privacy law for certain companies in certain circumstances to do risk assessments. What does that mean?
Yeah, so here's again, I see another influence from GDPR. And again, we see this across all the states in the US, but I'll start with California. What they're really concerned about is it's processing that creates a significant risk to the privacy or security of a consumer. And so I think, again, if we practice in this area, we're going to start getting really familiar with that term and this just concept of high risk data processing. Where are the lines, right? That's, there's going to be like a lot of things we do in law, like when we answer questions, or sometimes it's really clear yes, clear no, and then there's the gray area. And I'm sure we're going to have that in this area too of high risk processing. So if you're in that area of high risk processing, as a business, you're going to have to do these impact assessments. And it sounds very similar to what the EU requires, a data protection impact assessment for high risk processing. And what the statute says for CPRA is you identify and weigh the benefits resulting from the processing to the business, the consumer, the stakeholders, the public, against the risks, to the potential risks, to the rights of the consumer associated with such processing. And what's going to happen, I think, in practice, just like this is how the DPIA process works, is that you try to identify those risks, and then you try to find a mitigation or a control that, again, will sufficiently, or at least hopefully satisfy the regulator's view that you are sufficiently mitigating that risk. So that's what's in the statute. But in California, the new agency, the California Privacy Protection Agency, which I really recommend, get familiar with them. I'll talk about this more at the end of the talk of how to get more connected with them, but really follow what they're doing. I don't think I'm the only one, but I call them the new FTC in Sacramento. That's going to be a really important agency. And I just listened in recently to their board meeting, and many of their board members want to be a national leader. I mean, they are talking to the EU regulators, the Asian regulators, let alone the Fed. They really want to see themselves in a position of leadership. So, but what's interesting about that is they are going to have a lot of responsibility and authority to create rules that will help us as lawyers understand where these line drawing happen, and just mechanically, like how these risk assessments, how often do you do them? Can you do them internally? Do you have to do them independently? So we're waiting to hear from, and I'll talk about more of that at the end of what the timing of that is, but that should give you a general idea of what a risk assessment's about.
Yeah. Do other states have assessment requirements?
Yes. Yes, Virginia, Colorado, Connecticut. And what I think is going to also be interesting to see is California has been a leader, but what I heard in the last board meeting is one of the board members really wants to harmonize with Colorado. Like Colorado got faster out of the gate with their regs. They already have final regs. So I think there's going to be a lot of cross-pollination and interaction between these state regulators. So what's interesting, I did want to mention about Virginia, Colorado, and Connecticut, unlike California, is they actually get more detail. What do we consider as high-risk processing? So this you can put on your radar, for your clients. Targeted advertising. We know that was one of the big motivations of Alistair McTaggart in the first place. That consumers, you should know if your information is being used for targeted advertising, and you should be able to opt out. So if you are in that world, you've got a lot more, again, regulatory requirements. But then some others are going to be sensitive information, like we've been talking about. So if if you're processing biometrics, some of these, you're going to be in that area of risk assessment. And profiling, which again is really related to this. Learning about inferences and characteristics and about the individual consumer. So we know that those are going to be areas that these other states have already identified as requiring these impact assessments.
Great. I know there's increasing discussion around AI and automated decision making, and you mentioned that at the top of the session. What is automated decision making technology, and why do we need to think about it in this context?
Yeah. And again, this also came from the EU. They were really ahead of us. Some of you heard about the AI Act that's in the process of getting passed in the EU. And even in DC, there's a lot of activity. I think Senator Blumenthal was just having a hearing about it. So, it's everybody is talking about it. The way I like to think about it is I just call it the black box. So when decisions are being made in this black box, and let's use a simple example, without human involvement. So let's say it's about Jenny getting a job. I apply for a job. So somebody puts in my information, but there's already some other inputs, and this is where AI comes in, this machine learning, that has already been programmed to take my information and make a decision just an automated decision, should Jenny get a job here, or should she even get to go to the next level of get an interview here or not? So the way that the EU describes it, and I think, again, we're going to see that in the US too, is it creating legally significant effects? And so again, when you think about it, what really causes significant effects to us are things that affect our economic livelihood. So certainly if it's about a job, it's about a loan, but it could come up with many, many different things. But those are the kind of examples I like to start with, is thinking about those activities. If those are being done in a black box without any human involvement, basically what all the regulators are saying to business that does that is they're saying, hey, you have now an obligation to explain to the consumers and to us, the regulators, because we're going to determine whether we think it's a good enough explanation, is to explain how it works. And also, again, like in California, we're giving the right to opt out of that. So yeah, Megan and I had a discussion earlier, and we talked about a couple examples that I found very interesting in this area. New York City has passed a law that if you use, again, automated decision-making in hiring, you have to do a bias assessment. And one thing that many of you may have heard about this, but I found very interesting, is that Amazon, and I think this was a few years ago, but Amazon was using machine learning in their hiring, but they did analyze it and they found that it was discriminatory against women. And what was really kind of scary was they couldn't fix it. So they abandoned it and they're not using it. But I think, again, if you think about it, and this is where a lot of the activity is going on in AI now, is the training data. So, we all know, like in the US, that, we're always talking about gender, race, that we've had issues with that in hiring, right? And so if the box is based on prior hiring patterns, it's basically tainted, right? It's not really going to move us in the direction that we want to move in. And so that's where I think that there's going to be a lot of activity. And this is why, as privacy professionals, like, I love to go to conferences where I hear from data scientists, because they're on the cutting edge of, again, what do we do about this? How do we try to fix this? But yeah, it's a big issue. And so not just California, but yeah, the other states also have very similar, again, regulations now where the businesses have to explain what they're doing. Now, the only other thing I'd mention is a little different too with California, that was part of what Alistair did in Proposition 24. Most of the states are kind of following the EU that says if there's no human involvement, that's when you're in the use case there, right? I mean, the EU is already scrutinizing that, though, that you have to have real human involvement, so it's got to be substantive. But one of the things that was put into CPRA was, it gives the new agency the ability to regulate all ADM, even if there's human involvement. So that's one other little tidbit there. It's a little bit different with California.
Yeah, wow. I know we're sort of 20 minutes away from our end time, and we've covered a lot of information here today. It's just the tip of the iceberg. There's tons more to dive into. But as we sort of get towards wrapping up, I love to give audiences a real practical takeaway. And I know we talked about this. It would be great if you could sort of walk through your checklist of items you address with your clients in regard to CPRA.
Yeah, so again, my ABC Corp, one of the first things, and this is what I've been doing in 2023 with them, is I first go through this employee data for California. So let's get the notice and implement that. And again, that takes a little bit back and forth because I have a template, but then HR has to fill it out. I have to discuss it, add some more language to do that. And like I said, your companies are going to do that as part of your employee manual. And then got to revise the privacy policy. I said it's more similar to what I've done for the B2C, but I add the California users page. If they have also clients, so I have some clients that are law firms. that have individual clients, like they do trust and estates, and then they have business clients. So for them, I was already doing both the B2B and B2C analysis, but for my clients that were just B2B, we're adding the California users page, and then I've added Virginia now too. I think what you can look at what different companies are doing. There are some companies that, again, have the sort of laundry list, the 20-page privacy policy, and they've got, you know, a paragraph for each of these states. And some of them have already just said, oh, Colorado, when it comes into effect, here's what you get. That's one approach. But with my clients, what I've done is we've added, if they've got Virginia clients, we've added that notice too. But we're going to, it just seems like right now, I don't know what we'll do next year. We'll see, because I think in terms of the number of states, there's 5 in 2023. There's 3 other states that passed laws that are going to go into effect 2024, 2025, 2026. But the IAPP has a tracker, and the last time I looked at it, there were 15 states that had pending legislation. So we're almost to half of the union. You know, so maybe you'll have hyperlinks for every user, you know, again, like there's different ways to do it, but you've got to make sure that you've covered those other states. And then you have to evaluate if you need the do not sell my personal information and do not share my personal information. So my ABC company is not doing the cross-contextual behavioral advertising. But again, you need to look at that with your client, look at the statute. I have the IT, the marketing people talk about it, look at it. And, you know, again, sometimes there is a gray area, but as we all know from Sephora, the Attorney General believed you were not in the gray area. You needed to have that button, because California's definition of selling information, and now we call it sell or share, because Alistair wanted to make sure you did not get out of targeted advertising, but for any valuable consideration. So it's beyond monetary consideration. Then next, I evaluate if we're processing any sensitive information. And like for ABC Corp, we're assuming no. But if you did have sensitive information, then you could go through the exemptions. And you know what I always tell clients too, and you know, it's not always the thing that they want to hear, but I had to do this with GDPR, is like one of the bases that you can rely on is called something legitimate interest. But I had to explain to them, we can't just assert legitimate interests. We have to do an assessment. And so that means some lawyer time, because there's questions, there's discussion, and then you write that up. And that's what I recommend with any of these times. Like even when I did the B2B moratorium, I did an analysis and I had some attorney-client privilege backup for my clients of why we were taking this position. So the same with sensitive personal information. I think if you are in that area, you should have some backup for why you believe that the exception applies. Because it goes a long ways with regulators to show that, again, you gave some thought and attention to it. And then finally, is there high-risk processing? Is there any other activity that you're doing, including processing sensitive information, where you need to do an impact assessment? So that's my checklist.
A lot of things to keep in mind there, but helpful to get through all of that with your clients up front and get ahead of any potential issues. I know you had some interesting, you attended some interesting meetings this week. And so before we turn to questions or start to wrap up, we thought it could be helpful. What do you recommend the audience keep an eye out for at this point?
So I was able to attend most, not all, of the recent board meeting that they had. And it was interesting because I think this is what we're going to see going forward. You know, there's a particular law in California that prescribes how boards can operate. So they can't have any substantive discussions in private. If it's with the whole board and they're making decisions, it has to be in public. So this public meeting had staff people, because now they're staffing up the agency. They have an executive director, they have a general counsel, they have other senior counsel there now that are working on these regulations. And as you may know, what they did is they divided it into 2 parts. So they started with part one, that was the easier kind of update, add the correct and they added about the limit sensitive information, what is sensitive information. But some of these tougher topics about the cybersecurity audits, the impact assessments, that they are waiting for part two. And I went to a conference, and I also recommend, besides IAPP, if you're in California, join the privacy committee of the California Lawyers Association. They had their inaugural conference at UCLA in February, and the executive director from the agency was there. And what we were all looking for as practitioners, right, is how can we guide our clients for timing? Because there's this July date looming, right? Like, what's going to happen in July? Well, as far as the statute, the agency will have enforcement powers, and so will the Attorney General. Now, what we've been told all along is they're going to coordinate. So if the Attorney General wants to take something, then the agency will step down. But so these first regulations they worked on and they finalized, and I think in like March or April, they went through there's another review that has to be done in Sacramento. That was done. So those are final. I've been through those. But the second part, all they've done so far is they have invited questions and comments. And you can go on to, and again, I really recommend it's on the materials, the link of how to get there to the California Privacy Protection Agency and subscribe. So then you'll get notices whenever there's board meetings, but they also put documents. So you can read through what some of those comments have been. But what I found really interesting at the meeting was the senior attorney was presenting to the board and saying, here's what we've done. We've looked at potential regulation proposals, and it was 2 pages, about 20 items, and they color coded them from what they identified as easy, medium, or hard. So easy, they'll say things like language readily available, public record exists. But when it gets to medium or hard, they say requires significant research and pre-rulemaking activities. And a couple of the things that are on the hard are business to business data, employee data, some of the things that I'm really focused on with my clients. So what I heard, again, I don't know, this is what I heard, is next 6 months, what I heard was the next 6 months of staff can work on the easy and maybe some of the medium topics to get something for the board to approve. And then they were asking the board if there's anything in the hard category you want us to focus on, we can. So 6 months, that takes us to November. So again, there's still going to be regulatory activity. Nobody's getting off scot-free because CCPA is still there, just like Sephora found. There's been, again, this has been reported that the Attorney General sent out a bunch of letters to mobile apps, again, about the do not sell notices. So again, there's still going to be activity. But what it's sounding like is with this rulemaking, they're taking their time to do it right because they've got to build up a staff as well as work on. And again, these are all new topics in the US, right? This is all brand new. So I think again, that's why I said I think they're interacting with other states. A couple other takeaways I got out of hearing what the board members said, because they are kind of signaling to the staff, this is what we care about, was one board member talked a couple times about harmonizing with Colorado. So I'm going to be looking very carefully at the Colorado regs to see what is happening there. The another board member talked a lot about AI policy. And why don't we get in front of that as California and be a leader on that? So that was kind of general, but we'll see what that, what happens there. But like I said, in the meantime, get familiar, if you're not already, with some of these concepts from GDPR, because impact assessments, again, this is very similar to what we have in GDPR, and I think that's really going to be a cottage industry. That for privacy professionals, that companies that need to have that as, again, one of their regular business controls.
Fantastic. So we've got some time left for questions. One question here in the chat, and I know we touched on this a couple times in our prep for this. any talk or movement on a US federal law on personal data, or sort of what's your sense on that issue?
Yeah, I think the big blocker is California, and that comes up in the board meetings too. I think I have to talk about that, but they want California to be the floor, right? So they don't want a preemption that doesn't give Californians the same rights that they have now. So I think when the last one that was proposed last year, they got a certain amount of momentum. As I understand it, it was the California representatives that blocked that from going further. So I think what I hear, and we're not even getting into this topic, but another interesting topic for privacy professionals is the Children's Design Code that we have now in California that somewhat follow the UK one. You hear other states doing that, and maybe at the federal law, they're talking about children's data. So we might see other kinds of around the edges federal laws, but not a sweeping data privacy law. I'm guessing not probably for at least a couple years. I mean, there's another election coming, right? So I think for the time being, we're going to be dealing with this balkanization of different states. That's what it seems to me.
Yeah. Another question from the chat. We talked about harmonization, but until then, when you have companies who don't want to sort of rely on the links, they're hesitant about that link process, and want to keep everything sort of fully fleshed out in their documents. Have you had experiences with that, or with encouraging companies to feel better about relying on sort of incorporating the links throughout?
You were talking about in the privacy policy, having
Correct.
that
Yeah.
layered approach. Yeah, I haven't had any pushback from my clients. And like I always kind of start with, that's what the FTC recommends. So, and I find it just more readable as a user. I mean, like another thing that I started doing was in my format is I identify what is the type of personal data and what is it used for, rather than like a lot of companies like to do, just here's a list of all the data we collect and then go look somewhere else for what we do with it. Okay, if I'm a user, I don't follow that so well. Like, well, what are you doing with that information? Like, I have to then guess. So to me, I've always looked at it as what is going to be understandable and readable to the user.
Yeah. In terms of companies that may not be in the crosshairs just yet, but we all see where this is going, what do you think the next most likely limitation is coming, or what do you recommend they focus on to get ahead?
Oh my gosh, I just feel like isn't there already so many topics? I don't know, do you need another one?
Right.
I mean, what I'm spending my time on is trying to learn more about AI. When I went to the April conference at IAPP in DC, I was lucky enough to meet this young woman, very excited about this topic, and is starting a book club. So I'm joining her book club, and we're going to, read books to again understand what this is all about. And so that's a topic that's important to me is really understanding that. Like something again that we didn't talk about specifically, but it's something I have a very small group, a roundtable where we meet monthly and we rotate leading on different topics to share with each other. And they know like one of the big topics to me is anonymization. And thankfully to an IAPP conference I went to in 2019 where data scientists were talking about it, and they explained what a high bar that was to reach anonymization. So let's take my ABC company, right? One of the things that the SaaS company is very important to them is to be able to de-identify information so that they can learn about trends. Now, fortunately, in CCPA and CPRA, we have a definition of de-identify. That's, again, I'm not going to say it's not challenging, but it's not as tough as anonymization. So when I learned that from the IAPP conference, if I saw a template for a client and they wanted to say we anonymize, I had to say, well, how are you doing that? who is certifying that? And the fact is, from just a business, matter, we didn't need to say anonymize. Our clients were fine with de-identify. And then in the US, we tied that to the definition in CCPA. And I also tell my clients, hey, look at what that says, can't re-identify. There's even some more involved with CPRA to make sure you're meeting the de-identify. Have some documentation, do some things internally to be sure you are really, truly de-identifying. But, learning what anonymize means, pseudonymize, these are things that are really important for data privacy practitioners to understand. And it is dynamic, things are changing. So my biggest recommendation, as you know, Megan, is get involved with IAPP. They are an amazing community for knowledge sharing. I mean, it's just a wonderful community. Every region is constantly doing their own, both online and in person, doing events. I just thought about something on the layering. I'm just going to give a shout out to Lothar Detterman, who's Baker McKinsey, a privacy expert. He was the one that I heard talk at a conference before the pandemic that recommended this layering approach too, and that's how he was going to do the California users page. And he's got a book on California privacy that's very good.
Awesome. Another question here, and I know, Jenny, when we talked about some of this, the questions that might come up in our prep sessions, there's some things that are just going to require deeper dives, specialized, nuanced counsel, all of those things. So just couching that for these questions, and that we may not be able to answer them sort of in this setting.
I'm happy you'll get my contact information, reach out to me. And I have a wide network. If I don't know the answer, happy to get other people involved too. But yeah, a lot of times things are really contextual. So what are the questions?
So here's one. Under CPRA, how are contractors different from service providers?
Well, and that's a very good question. That we talk about that at my roundtable. We're still trying to figure that out. If you look at the language, it talks about service provider is on behalf of the business. Whereas with a contractor, the business makes it directly available to the contractor. Now, I'm sure, again, when CPRA was getting drafted, they had something in mind. All I can say is in my practice, it's all service providers. I haven't seen a situation where I'm like, oh, that's the contractor. But what's interesting, the way CPRA drafted this, is they made a little bit higher bar in that there has to be this certification that the contractor signs a certification that they are complying with CCPA versus the service provider. You got to have that written agreement. We often call those DPAs, data processing addendums. We had conflate it with what we have to do for the EU too. But yeah, we're waiting to see how that rolls out, because it was confusing to a lot of people.
Yeah. So there's definitely a lot to come on this topic. We're excited and hopeful that we'll be able to present a part 2 potentially later this year, or when it makes sense and the developments to be addressed have come to play. Jenny, I want to extend a huge thank you to you for your time and your thoughtfulness leading this program, and for sharing all of your experience and wisdom with us. We're grateful. Also, big shout out to the audience. Thank you for attending today. Again, this program was recorded and will be made available with on-demand access and the materials. The materials will include links to the websites Jenny referenced. I know there's been some questions in the chat about the author and title of the book you mentioned, and any other resources, so we'll collect those.
Reach out to me, I'll give them to you, Megan, or people can also reach out to me too.
Great, and we will include Jenny's contact information as well as contact information for myself and Paragon. We invite you to check out Paragon Legal, connect with us on LinkedIn, reach out to discuss ways we can work together to resolve any legal support needs you're facing, or to discuss joining our team of Paragon attorneys. CLE form will come to you along with the follow-up materials. If there are any other questions, please don't hesitate to reach out to us, but we hope everybody has a wonderful weekend.
Good. Thank you very much.
Thanks so much, Jenny.
My,
Bye-bye.
my pleasure. Bye-bye.